Okay, and we're now recording. So my name is Rob Litz with USA&M, and it's really our pleasure to present these best practice seminars now in a webinar format. We've been doing these for about 15 years, and I was just informed by Kelly Spiller of our office that this is the 75th CLE that our office have presented over those years. And it's really a pleasure that we provide this to members of our legal community, both the bench and the bar. The proceeds of these programs will go to both Legal Services of Eastern Missouri, an organization that we have supported for many, many years, and the Kornblum Food Pantry, serving more than 3,000 families on a monthly basis. And it's through the funds that you all provided in joining us today, and it's really a pleasure that we're going to provide funding to those very important nonprofits. Today's program, our 75th, is packed with things that are both timely and things that all of us need in terms of the ethics. I want you to jot down our next program. We've just set a date for January 28. And the time is really to be determined. And that will be based on some comments that you all provide with your evaluation. In the materials that Kelly sent you, there is an evaluation form. She will also be sending tomorrow morning a separate evaluation form. And one of the things we ask you to do is to let us know whether morning or afternoon is better for you. This is the first time we've done an afternoon. Traditionally had been on Friday mornings. So let us know that, and also let us know if there's some particular topics that are of interest to you. We know of one topic already, and that's going to touch on some dramatic changes that happened with the Title IX regulations that went into effect on May 14. It changes the dynamic of hearings of Title IX disputes, and also introduces the opportunity for what they call informal resolution, which includes mediation for the first time. These are not just colleges and universities, but also elementary and secondary schools throughout the country. And many of you may provide legal assistance to those particular clients. So we're happy to have that on our list of topics for the January 28 program. In addition today, those of you who need Illinois CLE credit, when you turn in the evaluation form, make sure that you let Kelly know that you'll need your Illinois CLE credit. Last but not least, there is a chat button at the bottom of your screen. And we ask if you have questions for our presenters today to put those in the chat. Those of us who are monitoring these sessions will keep an eye on them. Alan Pratzel, our first presenter, has asked that I ask the questions as we go along. The first program for our program today is on the topic of ethical trends and developments, COVID and beyond. Alan Pratzel is the Chief Disciplinary Counsel appointed by the Supreme Court in 2007. Alan has been so giving of his time over the years in presenting at our best practices seminar. He oversees the investigations, the ethics complaints against lawyers in the state of Missouri. He was previously in private practice for 30 years and is an adjunct professor at Washington U School of Law and University of Missouri Columbia. Alan, I'll turn this over to you, and if you would like to share your screen, we'll move forward. Thank you.
All right, thank you, Rob. Hopefully everyone can see. Thank you for having me today, Rob, and USA&M. I'm pleased to be here. Before everyone's video went off, I saw some very familiar faces, not through the system, just people who I know and share a friendship with. And I wish we could all be together and maybe we will be able to do that at some point in time. But in the meantime, I have been asked today to focus on the ethics rules that relate to COVID, practicing remotely, dealing with this pandemic. And I've decided I wanted to expand that a little bit to other types of disasters, because we're 8 months into this thing, and I'm sure most of you have been very successful in your practices these last months, whether you're working from the office or remotely. I see some backgrounds, or did see some backgrounds, where people appeared to be in their offices, unless it was virtual background, and other people who who seem to be connected from their homes. I myself am in my basement, sitting among a bunch of toys that my grandchildren play with, and that's because this way I can hardwire to the internet and not be have any connection problems. So you do what you have to do. So during this next period of time until about 2:20, I'm going to go through a lot of different rules that I'm sure most of you have already thought about in your practices during this current disaster. And there are going to be times when I sometimes come off as being preachy, like pointing my finger, well, do this or don't do that. And I do not mean to be that way. If I sound that way, it's just because I'm trying to get through this program. What I'm really trying to do is give you some assistance in terms of some of the ethics rules you should consider. The fact is that in terms of COVID-related complaints to our office, ethics complaints, there really haven't been a huge uptick in complaints. I think everyone's been dealing with this current situation effectively. And most of the rules that I'm going to actually talk about apply whether you're in a pandemic or some other disaster has occurred, or even pre-pandemic, things that you ought to be thinking about. So the first thing maybe we ought to do is set some parameters on just what is a disaster. In terms of the Oxford Dictionary, disaster is defined as a sudden accident or natural catastrophe that causes great damage or loss of life. This also includes a definition of any unfortunate consequences for us personally. And so with that type of definition, I thought I could expand my presentation to not only the pandemic and natural disasters, but also other things that happen to us as lawyers, losing our laptop or our iPhone or our client file. I think that's a disaster. A disciplinary complaint you may think of as a disaster, although these days, it's hard to get through an entire career without someone making a complaint against you. Sudden illness or accident to the lawyer that causes some sort of impairment. I'm going to try to address all of these through the next period of time until 2:20, and hopefully we'll get through everything. So when it comes to natural disasters, obviously COVID is at the top of the list, but here in the Midwest, the middle of the country, we've had other types of disasters that we are all familiar with. We've had tornadoes, floods, fires that may affect our practices, and even something as specific as storms and lightning strikes. All of these things can cause disasters to us and our ability to represent our clients. The first thing that I think becomes important from a macro point of view is a business continuation plan. Think about what would have to happen if your practice were suddenly shut down because of something that happened to you or some natural disaster. The things that I think need to be addressed in a general sense are your access to client files, whether they're electronic files or the paper files that you keep in your office and hopefully would still have some sort of available or access to. Your ability to communicate, whether it's with a client, an opposing counsel, or a judge, or anyone, or any other third party that's related to your law practice. Do you have a secure telephone line or a backup situation for communicating, whether it's by email, text, or otherwise? So some sort of communication means that it's secure and that you can rely on if the primary means to communicate is cut off for any reason. E-filing, obviously, throughout the state of Missouri is how we file our pleadings. Do you know yourself how to e-file? The fact is that I only recently learned how to do that myself in our office, and because I would rely on support staff. Well, in a disaster, you may not be able to have that access. You may need to file something through the e-filing system. And you should learn to do that and know how to do that in a pinch. And then access to your financial and other records that keep your office operating, your trust account records, the funds in your trust account that belong to your clients or third parties, maintaining some sort of access so that you can make timely payments out of those trust accounts, and also continued access to your business account funds. These are all important things that are necessary from a overall sense to keep your practice operating in any kind of disaster, including COVID. This next slide just identifies some of the rules I'm going to touch upon and some of the formal opinions and informal opinions issued by the Advisory Committee of the Supreme Court and the Legal Ethics Council. Those are, as you may already know, the Advisory Committee sits between our office, the Office of Chief Counsel, and the court, and provides important guidance on the interpretation of the rules through formal opinions. Melinda Bentley's office, Legal Ethics Council, provides informal advisory opinions. You can call her up and get an informal advisory opinion on the phone or in writing, and you will find a great tool in terms of planning for contingencies through those formal and informal opinions. But the rules themselves I want to touch upon first. The first thing to keep in mind is that even in a disaster, your clients are expecting you to comply with the ethics rules, right? In other words, disaster, whether it's a pandemic or something individually affecting you, these rules that we're going to talk about still apply. So Rule 4-1.3, the diligence rule, is short and sweet. You shall act with reasonable diligence and promptness in representing your clients. And while it's so easily stated, I can tell you that it's the second most common violation that is alleged through our office. Fully 40% of the complaints that we received in 2019 involved diligence, lawyers who failed to diligently provide for their clients within the representation. That can become even more challenging when a disaster strikes, as we're currently operating in. But the comments provide additional guidance that should help us. First of all, note in comment 1 that we should pursue a matter on behalf of our clients despite obstruction. The fact that there's a pandemic out there within reasonable grounds, we should be diligently representing our clients, notwithstanding these inconveniences, these obstructions, this opposition that may crop up to seemingly prevent us from diligently representing our clients. I think comment 2 becomes important in a disaster because it may be necessary to triage our workload. We all have multiple clients. Some have issues and legal matters that are more demanding and more immediate than some others, and it may be necessary, if we're working remotely or otherwise limited in our ability to access information and carry on a representation, we may need to triage that workload and those clients and make sure that we're handling the most immediate concerns right away, and perhaps for a temporary period of time, putting off matters that can wait a week, 2 weeks, or a month. Procrastination, comment 3, is always worth mentioning because I think it's part of human nature, whether you're a lawyer or anyone else. Some of us simply have this default to procrastinate things that we either aren't ready to deal with or don't want to deal with. And I think as lawyers, we need to develop tools to immediately deal with issues, whether they're making a difficult phone call to a client about some adverse ruling or whatever the case may be. We should not procrastinate those actions. Comment 3, the Rule 1.3 tells us this. And so it's something that some of us need to continually work on. And then comment 5 is important just generally for lawyers to have a continuation plan, and particularly so for solo and small firm lawyers, having some sort of plan for successor treatment of your clients in the event of hopefully incapacitation or other event happening to you. The diligence rule requires that we have a plan in place to handle our practice, to protect our clients, to have someone who can step in and transition that practice. So comment 5 is just a very important connection to dealing with any disaster, including COVID-19. And we will revisit that issue when we get to the later part of this presentation. Competence, the competence rule. Very straightforward. All of you, I'm sure, have the legal knowledge, skill, thoroughness, and preparation to handle your client representations. What I like to point out here, though, is comment 6 to Rule 1.1, I think becomes really important and relevant within a disaster, let's just say within a pandemic. And that is the comments to 1.1 tell us that being competent includes knowing the benefits and risks associated with relevant technology. And so as you carry out your practices, perhaps remotely, you should know some of the steps that need to be taken in order to protect your clients and take full advantage of available technology within your law practice. And we will touch on some of that as well. In terms of communication, we're dealing with situations in a pandemic or any disaster where we're anxious about our practices and other parts of our lives, and you just know that your clients have heightened anxiety regarding what's going on with their representation. They've hired you to do something. Is it being handled? What's going on? I need to find out. I start calling the lawyer. I'm not hearing back because the lawyer maybe isn't taking messages or is working remotely and hasn't checked voicemail at work. The point is that you have a continuing obligation, I think, to communicate with your clients, and perhaps pretty quickly. We're 8 months, as I said, into this. Hopefully you've all talked to your clients and let them know that you're on top of everything, as I'm sure you are. But things come up and you have a continuing obligation to communicate with those clients in a reasonable fashion so that they stay up to date with regard to what you're doing. And in redoubling those efforts, we have tools these days that make it easier for us to communicate. You don't have to write a letter. You can send an email. You can send a text. You use your telephone, your cell phone to communicate with them. There may be situations where in your representation agreement you said you are not going to take texts or communicate by text, but maybe you want to bend that rule a little bit within a disaster situation and start communicating with your clients by ways that you might not otherwise be willing to do. In-person meetings become very difficult in these times. And so Zoom becomes important. You may need to know, how do I set up a Zoom meeting and invite my client to that Zoom meeting so we can have a face-to-face session? Is Zoom a confidential way to communicate? It seems to be the default way to communicate, but there are other means to communicate through other techniques like WebEx that some people say is even more secure. So just be aware of security issues, confidentiality issues, but nevertheless, keep that communication up. I know of some lawyers who, one of the things they have kind of led up on doing is checking voicemails at work. If your clients don't know how to contact you and you're working remotely, you may have backed up voicemails at work that you need to answer. And so on a regular basis, you should be checking your voicemails. Hopefully someone perhaps steps in at work on an occasion, takes those voicemails, forwards them on to you so that you can keep this level of communication satisfactory within Rule 4-1.4. Now, I always do like to point out at this point that, the rule only calls for reasonable communication. And while there may be some need for heightened communication, as you're working remotely, just to make sure your clients are satisfied that everything's being handled. If you have that type of client who's calling you multiple times a day because they're just that type of client, that is not a Rule 1.4 requirement that you call every client back every time they call. It only requires reasonable communication, which in my view certainly involves an initial contact to let them know how to contact you and what's going on in their case, and then communicating with them as developments occur within their representation, whether it's a litigation matter or a transactional matter. 1.6, confidentiality. Obviously, confidentiality becomes very important. To me, if you're working remotely, either full-time at your house or just part-time on some days, just be aware of the need to maintain confidentiality within your household. I think it's advisable to have an office space where you can work in a secure area without being heard. If you're having conversations with clients, they should be secure communications. Subsection C is important in a disaster because it tells us that the lawyer is required ethically to take reasonable efforts to prevent the inadvertent or unauthorized disclosure or access to information relating to client representations, confidential information. And so what are we talking about here? Well, if you're working remotely, I think it's important to have secure Wi-Fi connections or secure internet connections. If you're using VPN to connect to your office desktop, that should certainly be a secure connection. If you're working from a home computer and doing your office work, do you have all of your malware and virus protection updated on your computer? Very important that you do that. Have necessary firewalls in place. Data breaches are more common now than they ever were, and I think have probably increased significantly during this period of time, these last many months. And even the largest companies in the world are getting hacked and having data breaches. Remember that 1.6C only requires reasonable efforts. As long as you've taken those reasonable efforts, if something does happen where there's an unauthorized access or disclosure by some third-party hacker, and you've made those reasonable efforts, you will not be held responsible for that breach. Notice on this next slide a reference to 5.1 and 5.3. This is important because to the extent that I'm sure you all have either supervise lawyers in your office, you're in a supervisory role, or you have just support staff who work for you, admin assistants, paralegals, investigators, whatever the case may be. Remember that you have an ongoing obligation under Rule 4-5.1 for the lawyers in your office who you supervise and have a supervisory role over, in terms of making sure that you have taken reasonable efforts to make sure that they are complying with their ethical obligations. And so, some of the things that we're talking about today, you should go over with them and make sure that if they're working remotely, that they have this virus protection, that they're working in a safe environments in terms of confidentiality. You have that obligation to make those reasonable efforts. Same thing under 5.3 for non-lawyer assistants. Any lawyer who works with someone in the office and supervises them, so it could be the most senior attorney in a firm to the newest associate, has a 5.3 obligation with regard to their non-lawyer support staff that they supervise, to make sure that they're aware of the confidentiality rules and the other ethics rules that they should be sensitive to in terms of the lawyer's obligation. In other words, if you have a paralegal who you supervise who goes on Facebook at night and gives out client information on Facebook, they are not subject to 1.6. They're non-lawyers. So what are we going to do? We're going to simply look to see, well, were they supervised properly? Did they know about 1.6? Did the lawyer supervising them in the firm give them that training and knowledge such that when they went out and did that, it was not the lawyer's responsibility? That's going to be the extent of our analysis of that type of situation. Let me just stop for a moment. Rob, are there any questions at all that right now, because I've been talking a lot and probably haven't given you a chance to break in?
Not so far.
Good.
We're in good shape. So I'll
Excellent.
let you carry on. Thank you.
Thank you, Rob. Backup systems, just state of the art these days, that lawyers, rather than having their servers backed up on site, they use cloud backup systems, and that's fine, subject to certain limitations that you should be aware of and sensitive to. In this area, we have an advisory, informal advisory opinion 2018-09. And by the way, you can access these formal opinions and informal opinions on the Legal Ethics Council website. Just Google Missouri Legal Ethics Council and you will find your way into their informal opinions. 2018-09 tells us that as part of competence, confidentiality, and supervising non-lawyer service providers, 5.3 would apply not only to your non-lawyer staff, but also third-party non-lawyers. You have certain obligations, and your terms and conditions of service should address certain specific items to make sure that you're controlling the client data and information that you're putting into the cloud. And one thing that you may want to consider, I know at our office, we have an IT professional that helps us with all of our backups. We don't use a cloud system, but we have IT assistance, and you may in this area want to get some at least temporary IT support to make sure that your cloud backup system is compliant with the rules. What are some of the things that the advisory opinion tells us we should be sensitive to with these cloud computing agreements? The first is that the confidentiality of client information is protected by the third-party provider through transmission and storage. If there is some sort of security breach, your agreement with that third-party cloud provider should provide that you are immediately notified of any security breaches so that you can take corrective action while they're doing the same thing. You know, there are cases these days that we've heard about where litigants subpoena cloud providers for client information. And obviously that's something that you need to know about if that were to happen with regard to any provider that you're working with. So that agreement should provide that you're notified immediately of any subpoena for client information so that you can take action to try to quash that type of attempt to collect client information. Who owns this data that you're putting into the cloud? Well, your client does, but it should be you and your firm that have control and ownership of that data that you're storing on the cloud. And that agreement should make clear that the ownership of that information. The agreement, the informal opinion tells us that the agreement should make clear that the provider has no access rights to the client information unless it's required by law or court order. That the system is backed up regularly, that the provider is backing up your data and your client information on a regular basis. What's going to happen to this data in the event that you terminate your contract with the provider? Is the data going to be deleted from the clouds and given back to you in a timely fashion? This should be obviously a requirement. That you will have reliable access to the information and that there'll be no access by third parties, and that no advertisers or other third parties will be given access to your client's data. And then I think the informal opinion makes clear that preference is that data be stored domestically and at least in a jurisdiction where the provider is subject to the laws of the United States for purposes of contract law and enforcing those contracts. So, you know, it's common these days in a disaster. It becomes even more important perhaps to access that data, and those are some of the rules you should be familiar with. Trust accounts, obviously in a disaster, you need to make sure that you're properly handling your trust account funds. I'm not going to spend a lot of time on this rule because I think we all know what the rules are. The thing to keep in mind is that your trust account records need to be kept for 6 years after termination of the representation or the last disbursement. And it's important, unlike client files where you can change how long you keep and change and reduce the amount of time you keep a client file, with regard to trust account records, you are required to keep those records for 6 years from that termination of the representation or last disbursement. Lawyers with 5.3 comes into play here. If you have managerial authority within the firm for your trust accounts and you're working remotely, you need to make sure that you're still maintaining control of your trust account. 1.15 and 5.3 require that only a lawyer own that account and be the signatory on the account. However, you can have a non-lawyer who is under your direct supervision also be a signatory. So just be aware that in these cases, you should take heightened protection of those funds, which are not yours. They belong to clients and third parties. And again, under 5.3, when there is a breach of that trust account by some third party within the firm, perhaps an office manager is what we've seen most commonly, where there's a theft of money, we're going to look to 5.3 to see what steps you took to protect that client money. I think we can, in the name of time, move past this. This is just 5.3, some of what the black letter law rule is. And it makes clear in A that any partner or lawyer with supervisory authority, managerial authority, have reasonable assurance that every person's conduct, every lawyer's conduct in the firm is consistent with the ethics rules. And then we go on to under 5.3, every lawyer has that responsibility under subsection C. The thing to keep in mind about 5.3 is as I just mentioned, is that it includes not only your employee non-lawyer staff, but also any outside providers outside the firm. These days, there are lawyers and law firms that hire investigative and paraprofessional service companies that assist with litigation, document management companies, third parties, printing companies, scanning companies to assist with litigation and preparing for trial, and these computer cloud storage companies that store client information. Again, these are all people that 5.3 applies to, and companies that 5.3 applies to in terms of making reasonable efforts to protect confidentiality, to protect the diligence rule and the competence rule. So let's talk for a moment about client files. Again, this may not directly relate to the pandemic, but it's never a bad thing to refresh our memory about how long do I have to keep a client file. And the rule is 4-1.22, and remember that it tells us that if the file, it splits the time requirements based on when the representation ended and that client file was closed. If the client file was closed before July 1, 2016, the old rule applies. You have to keep that client file for 10 years. If it's a client file closed within the last 4 years since July 1, 2016, the new rule applies. You only need to keep the client file for 6 years. And so, one of the reasons the court reduced this timeline from 10 to 6 years back in 2015 was we were kind of outliers among the 50 states. I think we and one other state, I believe Colorado, had this 10-year requirement. Just about every other state had a reduced timeline of between 5 and 6 years. So our court thought it appropriate to reduce the timeline for Missouri lawyers to 6 years. Keep in mind that with regard to client files, not trust account records, but client files, you can agree with the client to a different time frame. You can actually shorten it from even 6 years to a shorter period of time. It only applies to the client file, not the client's trust account records. It requires informed consent in writing by the client to a shorter period of time. A lot of lawyers do that within the representation agreement. And that's fine, provided you've given the client informed consent, told them the risks and benefits of a shorter time frame, pros and cons, whatever the case may be. You have to maintain a record of that client agreeing to a shorter time frame for the full period of 6 years. So you can't destroy that. If you've gotten the client to agree to a 4 or 5 year time frame, you have to keep that record of that client agreement for 6 years. Remember that there are situations where you cannot destroy a file even if the client has agreed. There are 4 situations in the comments to the rule. One is if a legal malpractice claim relating to your representation of that client is pending, you have to keep the client file. If there's a criminal or government investigation, you have to keep the client file. If there's a complaint to our office, the Office of Chief Disciplinary Counsel in Rule 5, relating to the representation, you have to keep the client file intact. And if there's any other litigation that's pending that relates in any way to the representation, you have to keep the file. So absent those 4 requirements, you can agree to a lesser time and destroy the file sooner. Obviously, the destruction has to be in a secure fashion through shredding, incineration, something that totally destroys that file. You should, and I think we all know from law school that you cannot ever destroy items with intrinsic value, such as wills, trusts, deeds, things like that. So to the extent that you're dealing with that, you have to maintain those records. There are some additional rules that the court approved when it most recently adopted 4-1.22. We had a couple of situations where law firms would dissolve and no one would take responsibility for the client files, and it became a difficult situation. So the rule now provides that upon dissolution of a firm or sale of a law practice, the firm has to make arrangements for maintaining those files within the rules, whatever time frame applies. And someone who's responsible for that arrangement has to be able to be contacted. Obviously, I've just touched on the fact that when you do destroy client files, they have to be done in a confidential manner. 1.15 is always important to mention. The couples case also, who owns the client file? Your client owes you money, has terminated your representation, or you've terminated the representation, and the client owes you money and they want their file back. Can you hold the file hostage? The answer is no, under formal opinion 1.115 and also under the couples case. That client file front to back belongs to the client and cannot be held hostage in return for an unpaid fee. The only exception is for transcript costs. You took a deposition in a piece of litigation, you advanced the client the cost of that deposition transcript, you then had the attorney-client relationship terminated. Do you have to give them the transcript? There's exceptions for that. You can require payment of that transcript cost before you turn the transcript file over. Everything else, front to back, including work product, including privileged information, goes to the client or to successor counsel as directed by the client. And then of assistance to lawyers, especially perhaps in a pandemic or any other disaster, is that formal opinion 127 allows you to scan your client files. So, those of you who have huge storage spaces filled with client files, if you're able to do so, you can start scanning those files. The only caveat is that they have to be readily accessible to the lawyer and have to be subject to reproduction to the client if requested. If the client says, yeah, you can send me on a thumb drive my file, that's fine. But if they want it back in paper, you have to convert that file back to paper and give it to the client. Can you charge the client for the cost of copying the file? No, because there's no requirement that you actually keep the original paper file. They are entitled to the paper file. If you want to keep a copy, go for it. That's absolutely fine ethically. It's at your cost. So let's talk quickly about losing a laptop, phone, file. Just touching on three rules, obviously, that get impacted by that type of event, that I would call a disaster. One is confidentiality. You lose your laptop, there's some 1.6 issues involved. Hopefully, and I think best practices and 1.6 would require under subsection C, your computer should be password protected so that if something were to happen to it, it would be difficult for anyone to break in and access that client data. It should be protected with a very strong password, and you can determine that through the research of what the strongest passwords are and what they should include. The information in that laptop should be encrypted if possible, so that anyone who were able to break into your laptop would not necessarily be able to read what's on your laptop. Communication becomes important, being able to maintain communications with your client. And by the way, if you lose that client file or that laptop with client information such that their confidential information is subject to disclosure, I think that's an event that calls for communication to the client. Unless you're able to immediately find that laptop and secure it. Then diligence. Ask yourself, if you were to lose this paper file or this electronic file, what would happen? Do you have a backup in place? Could you still recreate that file? If you don't have one, the answer to that question is, well, I'm just out of luck, then you should make sure you're backing up to a secure location your client files that are electronically stored. So disciplinary complaints. I'm not going to deal with malpractice because that's not what we do. But let's talk about disciplinary complaints. What are some of the things to be aware of? As I already mentioned in passing, 1.3, 1.4, just the most common complaints we get every year. They may switch places, but there are always one or two on our hit list of complaints that are received in our office. Declining or terminating a representation based on a complaint being filed against you. That's up to the judge. We are deferential towards the judiciary. If you seek leave from a court in a pending case to withdraw from that case based on the fact that your client has filed an ethics complaint against you, and leave is granted, we're fine with that, because it does have an effect on the attorney-client relationship. Absent that, though, absent leave from a judge in your pending case, you have a continuing obligation to deal with that client until you've been given permission to withdraw in a litigation setting. In a transactional setting, it's more unilateral. You can terminate that representation provided that you're not materially adversely impacting your client's interest by that withdrawal. A couple things that I'd like to mention and with regard to ethics complaints, and you're continuing to deal with a client. I get a lot of calls from people who just had a complaint filed. Do I have to still, my client's calling me. I have a deposition scheduled for this client who just filed a complaint in this case. Should I be talking to the client? You have a continuing obligation under 1.4 to communicate with the client. And then what happens when you have some sort of issue with the client that you resolve in a monetary sense? Maybe you missed the statute. They filed a complaint against you and you settled the underlying missed statute of limitations. Can you include in your settlement agreement with your client regarding their legal malpractice claim that they either won't file an ethics complaint against you, or that they won't cooperate, or that they will withdraw their pending ethics complaint? Formal opinion 122, it's very specific on that and says you cannot include a provision in a settlement agreement with a client resolving some claim of negligence by having them not cooperate with our office in terms of filing or pursuing a ethics complaint. Now, what happens if it's the client's idea to withdraw their complaint? That's fine. I get all the calls all the time. Well, I didn't suggest it, but the client suggested that they'll write the OCDC and withdraw the complaint. If it's their idea, you haven't prodded them to do it, we have no problem with that. But you should be aware that Rule 5.17 of Supreme Court Rule 5 makes very clear that the fact that the complainant, in most cases the client, has decided not to pursue the ethics complaint and wants to withdraw it is not grounds for us dismissing the ethics complaint. There are times when I will unilaterally look at a file and say, yes, based on this withdrawal and what the client has said in the withdrawal, I think that we can close this without additional investigation. But generally, we're going to require at least a response from the attorney before we do that. So just be aware you cannot require that as part of a settlement of your dispute with your client. Informal opinion 200-50059 makes clear that you have a continuing obligation to communicate with your client and to represent your client according to the rules. That said, again, if you get a court to grant leave to withdraw, we will not second guess that. We do get complaints where supplemental complaints. Well, now my lawyer has withdrawn and gotten permission from the court. Well, as long as you followed the rules and given your client notice that you filed the motion and the date it was called up before the court under subsection D of 1.16, that's fine. We're not going to, again, second guess the judge. And then on this slide, there's a informal opinion regarding lawyer mistakes and what kind of communications are required. I'll let you review that yourself if you deem it appropriate. So just be aware that these are the rules that seem to me to apply to that type of situation. I want to get through to this last section, which is something that we actually have seen, not just because of pandemic related issues, but in the last several years, we've seen an increased situation where we have lawyers who simply are impaired for some reason, maybe because of age-related dementia, substance abuse, mental health issues, whatever the case may be. But we have this baby boom generation of lawyers, of which I'm a member, that are getting up in age, and some lawyers who maybe are starting to suffer from some cognitive difficulties that are preventing them from diligently and competently representing their clients. This we have seen occur. Just be aware that this impacts the trustee rule and the diligence rule. In particular, the diligence rule tells us, and I come back to comment 5, you should have a transition plan in place in the event that something sudden happens. And it's not just older lawyers. This can happen to any person at any stage in their life, that they suffer something that prevents them from representing their clients in a proper manner. Comment 5 encourages lawyers to have this continuation plan in place in the event of death or incapacity. It's so important to do that. And why? Because to me, it's really a key component of diligence. To fully and diligently represent your clients, think about the end game. Is my client protected? I'm a solo practitioner. Is my client protected in the event that some sudden event occurred to me, either within a pandemic or otherwise? And so that, to me, it's part of being competent and diligent towards your clients. Rule 5.26 was added to in 2017 by the court, so that hopefully you've all seen on your annual enrollment statements that there's now a place for you on a permissive basis, not mandated. You'll see in line 2 the word may, not must, to name a trustee, someone who has agreed with you, maybe on a reciprocal basis, to transition each other's practices in the event of some impairment or death, something like that. All I can do is encourage you, if you don't have one of those in place, one of those agreements, to talk with someone who you trust and have a close relationship with, another lawyer, to get that in place and notify the court on your enrollment statement next year, because it's just so important to have that in place. And the reason is because of what happens when you don't have that in place and then something happens to you. You either pass away suddenly or you become suddenly impaired, and we have to have a trustee appointed. Our office goes out, finds somebody to act as a trustee and get appointed by the presiding judge in that judicial circuit. We get involved. We end up transitioning that practice, contacting the clients, doing everything that should have been done, but in a way that really the clients become very confused and agitated. They're getting contacted by our office or by a trustee that we got appointed versus someone who the lawyer has designated to handle that matter. It's not such an issue in large firms. Those firms deal with the death of other lawyers within the firm or incapacity. Small firms, sometimes someone steps in. Solo practitioners, it becomes more difficult. So we have seen an uptick in this, and I just encourage you to think about that. 1.16 is on this slide, and I'm right at time. I just want to mention that, arguably, well, not arguably, 1.16a makes it mandatory for you to withdraw from your client representations if your physical or mental condition is such that it impairs your ability to represent clients. When that happens, we try to get it resolved without having to use some of the tools in our tool chest to force that lawyer to take retirement, to go inactive or otherwise step away from the practice. It's not a pleasant situation, but when we have to do it, we do use our tools to protect the public and the bar's integrities, because that is our mission statement to the extent we have one. So I'm right at time, Rob. Any questions?
There was one quick one that I'll ask. If a client terminates the lawyer's relationship but does not pay, and say 3 or 4 years pass, can the lawyer send the client an email asking the client if he wants the lawyer to send the file back, say within a month? The lawyer then asks, can you destroy the file if the client fails to ask for it within that time?
If the client fails to act within that time, ask for it or respond to your query about, well, do you want your file back? I think the rule allows you to go forward, certainly at the 6-year point, or if you've agreed to a lesser time. And that's something that can be written into the representation agreement to make that clear to the client. You know what, we've agreed to 4 years. I'm going to write you after 3.5 years and give you a window to get your file back, but at 4 years, I'm going to assume your consent to destruction, and I'm going to destroy that file. I think that is absolutely fine.
Okay, very good. Well, Alan, I want to thank you so
You
much.
bet.
Another outstanding program. I know there was a lot of material for all of those who were in attendance. The PowerPoint slide deck that Alan has, and it goes for, gosh, another 4 or 5 pages. So another 8 or 10 slides. This is really important for us all. I would frankly recommend take it, save it, look it over, because we're dealing with things, especially the example you gave of the 5.26, where you designate a trustee. With COVID, we could be feeling fine today and
Right.
be in the hospital in ICU tomorrow.
Right.
So I think those who are in practice would be wise to would look at it designating someone as a trustee, really for the benefit of the clients.
Great advice. Thank you, Rob.
Well, Alan, thank you. Another terrific program, always giving of his time and expertise, both for our best practice seminars and, of course, helping to educate young law students, both at WashU and Mizzou. And Alan, thank you again, and be well and stay safe.
Thank you. Same to all of you. Thank you all.
Okay. So I have about 23 after. Why don't we take a break of just about 5 minutes? We'll have our next segment start at 2:30. Thanks so much. Okay, and we'll get started. Our next program, Practitioner's View of Mediating Remotely, Advocacy Techniques and Secrets. Judge Pat Reel, who is part of the mediator panel and senior arbitrator panel here at USA&M, will be moderating this part of our program. Let me just introduce Judge Reel briefly. She served with distinction at all levels as a judge in Jefferson County, circuit judge, associate circuit judge, a commissioner in the 23rd Judicial Circuit, and also served as a city judge, municipal court judge for 2 different municipalities of DeSoto and Crystal City. Judge Reel has also joined a specialty panel at USA&M of 8 of our mediators who will be available to both mediate Title IX disputes under the new regulations, as well as serving as hearing officers. Judge Reel, I'll let you introduce our panelists. Thank you.
Thank you, Rob. This afternoon, we have with us, it's my pleasure to introduce our 2 panelists. We have Gary Berger, who is a St. Louis city-based trial attorney representing individuals and a founding member of Berger Law. We have also with us Stephen Strum, who is a partner at Sandberg, Phoenix, and Van Goddard, having represented both plaintiffs and defendants in over 200 mediations throughout the country. He is noted for his work in healthcare, insurance, and product liability. And gentlemen, please share your tips about remote mediation with us.
Well, thanks a lot, Judge, for introducing us. Good afternoon, Steve. How you doing?
Very well, Gary.
So
go ahead.
So, Steve, I was, we're litigating in a pandemic and mediating in a pandemic. Some people are a little recalcitrant to jump into this forum to resolve disputes. I know you and I are doing it. We've done Zoom depositions and that kind of stuff. But what do you have to tell folks who are kind of orient folks on taking the first step to engage in this process?
Sure. Well, many of us didn't know the word Zoom before March of this year. And now everybody is familiar with that word. And I will say this, because people are nervous about it. There are some people that are not technologically savvy. We all can, I guess many of us can think about times we've been in front of a jury and the TV didn't work or the video didn't work or some sort of technology didn't work. And there's probably no more nerve-wracking time when you've got all those eyes on you. I will tell you this, things go wrong, technology goes wrong in the Zoom mediations at times, and you get through it. Right now, we've got 81 people that are on this call, and it's working. So this is something that is not just here, and then once the vaccine is out, this is going to go away. Our restaurants may open up, but I do believe that Zoom mediation is something that is here, and it's here to stay for a variety of reasons. Very briefly, it is much more cost effective. Clients do not have to get on airplanes. The lawyers do not have to get on airplanes. We can sit in our own homes and we can settle cases. I've done now, since the pandemic began, I have done 22 mediations by Zoom as a lawyer and several as a mediator. And to say that they have gone well is an understatement. There are some things that are missing that we'll talk about, but overall, I don't think anybody should be afraid of it. And I think it is something that is here to stay.
I concur, Steve. You know, my experience is the days of a big, long, open session where each party tells each other their case is long gone. We end up being in private caucuses for much of the mediations anyway. And since I've done a bunch, I don't know if I've done 22, but I've done over 15 since March, and I've just found new ways to do it. Trying to, just like anytime technology changes, whether it's trial, whether it's mediation, you just kind of do some other things to try to have the same efficacy in a mediation as any other time. Does a Zoom mediation, Steve, change the way you prepare and get ready for a mediation with your client?
You know, for me, it does not. I've got sophisticated clients. They are, in-house general counsel. They are claims people from insurance companies. And we share information, we caucus the case, we discuss the case long before we get into the Zoom mediation, which is not any different than what we did when it was, in real life. There are some things that you've got to think about ahead of time in terms of exhibits. It becomes a little more clumsy than getting something out of your briefcase and giving it to one of the mediators and saying, I want to present this issue to you. I want you to present it to them. But they are issues that you can get through. So it's not, the prep part is really not much different for me. It may be for you, which I know that you'll share, but not for me.
Well, let me share that now. So one of the things I've found in the pandemic is it's forced me to redouble my efforts in communication, both with my office, with the procedures I have, so other than my wife, I have no problems with communication. But there's my throwaway joke. I'll have probably one more. But no, truly, it's really shown where breakdowns in communication happens, whether it's staff working at home we're not talking in the office together. So I'm talking to my attorneys and support staff about communicating, talking, phone, emails, that kind of stuff. I'm also doing that with clients. So let me share briefly. I did prepare something. This should be in the prepared materials, but let me share a screen here with something that I do, and it's a protocol that I did that are my steps. Can you guys see this? Can you see the share screen?
There's nothing, I don't have anything other than it says Gary Berger has started screen sharing. There it is.
You see it there? So this is in the materials. I'm just going to take folks through it real quick. So what I did is this is an internal step-by-step memo that I've done for my staff where how we get ready for it. And I found that if you decide you want to settle a case, one of the most important ways to be successful is how you get there. And And so we schedule the mediation. At the time we scheduling, we send an email. I have a form email that we send to all of my clients that's going to explain the mediation. And again, I know I'm flying through this quickly, but this is everybody has this in their material. This is going to explain to my clients in writing what happens in a mediation and what some of the things that can happen are. So they say that if you do anything 3 or 4 times, you either should video it for your clients or you type it out for your clients. So that's what I've done there. And that eliminates steps and eliminate a conversation so the client gets that. And then I have a call with the client explaining it. And we also do things like running up to a mediation. Are there any other medical bills out there? Have you given me all your wage loss stuff? Have you gotten any other lien notices? That kind of stuff. We also make sure that we have updated medical records and all of that stuff. I mean, how many times are you in a mediation where like, oh, there's an extra medical bill? And that, Steve, that doesn't help you and your clients because you need to have everything ahead of time. Probably most importantly, what I do is in a week to 10 days before the mediation, and I'm highlighting this, I do my mediation letter to the mediator. I'll do the letter to Judge Reel or to Rob Litz, and I'll say, and I'll do my mediation letter. And I will always send my mediation letter to the opposing counsel, to Steve, because if I want to settle this case, I don't want to leave my cards on the table. What I want to do is send it to Steve and so that he can send it to his adjuster, because his adjuster needs to read and digest it. And there may be supervisors that need to read and digest it. There may be committees. We have to run that up the flagpole because it's harder for Steve or the defendant in a mediation to make adjustments and get more authority. So if I want to get paid for additional medical or additional wage loss documents or a good witness or a lien that I've reduced or some of this other stuff, then I want to show them that ahead of time. And I can spend more time doing it, but I don't want to bore you all too much with this screen share. But if you look in the materials, I have literally a step-by-step guide of what my staff does. And the reason why I do that, Steve, is I've learned that lesson. We always do stuff because we've learned the lesson the hard way, right? So, just like errors in trial, I've been walking into trial going, wait a minute, can I get my medical in? So the same thing in a mediation is when I'm walking the day before the mediation, I don't want to sit in there and say, well, I never contacted the lien holders. One of the other things, because liens are such a big deal, Steve, as you know, and can be a make or break a deal in settling a case. 2-3 weeks, a month before the mediation, I am writing letters to the lien holders asking for reductions already. Now, I may not have that deal cut before I get into the mediation, but I'm a long way there, and I have ability to talk to my client a little bit more about what's in their pocket. I have a little bit more distance to go, a little bit more road to travel to get my client ready for this than you do. But if you spend a little bit of time, and with this new technology, the Zoom, I'm kind of doubling down on it, trying to surrender to it, accept it. And the more I get my clients up to speed, then by the time we walk in that mediation, they know the process, they know the numbers, they know some of the things we're talking about, and it's more ripe for success. The question I had for you, Steve, and I'm ambushing you with this a little bit, is for a long time now, I've been sending my mediation letters to the defense lawyer. What do you think about plaintiffs or people on the other side either sending the mediation letter to you and showing you all my cards versus someone who's playing the cards out during the mediation? What's a better process, or what are your thoughts?
I don't really, I think either one is fine. I'm one that doesn't look at it as mediation really much differently than one in person. It's documents and openings and caucusing and things like that. So, I'm fine with it either way.
Okay.
Judge, I wouldn't mind, Gary, I'm sorry, were you finished?
Yeah, go ahead. I was going to throw it to you for a minute.
Yeah, Judge, I don't know if you have some specific areas you'd like to go into right now. I would like to talk a little bit about, sort of just the logistics, sort of the good, the bad, and the ugly of Zoom mediation to try to make people feel more comfortable with the process.
I think that would be an excellent idea.
All right. So I guess there's two things that are most disappointing about doing a Zoom mediation and not going to the USA&M offices. And one of them is their wonderful staff. And unfortunately, we don't get to see the smiling faces of Kelly and Tammy and Gretchen. And the second is we don't get the candy. Those are the two downs of doing this by Zoom. Other than that, it's a wonderful process, as I said before. And but let me go through some of the logistical things to consider if you have not already done it. And for those that have done it and I missed something, send a chat and let's talk it through. One of those obviously is making sure that you have a solid web, internet link. And that sometimes is not as easy as it sounds. I'll give you an example. When USA&M sends me a link for a mediation, it goes to my office. It goes to my office email. When I'm at home, I obviously can access my office email through our network. I learned early on that if I click the link through my office email, it is not stable, it is glitchy, it freezes. And I realized because it's going through essentially at least two different systems. So what I do every single time is I take that link and I copy and paste it and I send it to, for instance, my Yahoo account. And then I get access to my email on my Yahoo account. I click the link there and I have much, much better internet service. Some of you may not have that issue, but I learned that early on that was a way of getting around that. One of the other things too to consider is sometimes, for instance, right now, I am downtown for the third time since March in my office. I don't get great internet service here in my office. And my screen behind me doesn't have a camera. So I am actually hotspotting right now through my cell phone. There are times when you have to do that, not just because of what I'm dealing with right now, but you might be somewhere where you have either no internet service or weak internet service, you have strong cell service. And in those circumstances, then you can just set your phone to a hotspot, and then you can hotspot in your computer, your Surface, your iPad, whatever it is that you're using. Obviously, kids, dogs, those people on this call that have acted as my mediator know how loud my dogs are. And sometimes I can't keep them quiet. And so I warn them at the beginning, if you see that I'm on mute, it doesn't mean that I don't know what I'm doing. It's because the dogs are barking or my kids are screaming at each other. So those are just things that they just happen. That's the world of doing this stuff from home. Clothing, I won't give any current examples, but we all should be cognizant of what we're wearing. And if we decide that we have a different outfit north of our waist than south of our waist, then just be aware of that when you get up and the camera is on and you walk away from the camera. Be aware of cameras and microphones. Sometimes you think your microphone is off and you are saying some things, whether they are specific to your case or they are, you're barking at somebody. You need to be very aware of that. In terms of security, I have some clients that do not feel particularly secure with communicating with me once the mediator leaves the room. And it's time for us to have our discussion and to come up with a number. I have some clients that just don't feel comfortable doing that on the Zoom call, which is fine. Then I pick up my cell phone and we have that discussion on the cell phone, or we're emailing, or we are texting, and we're figuring out what is a way that is most comfortable for the client. I am perfectly fine with the security of Zoom, but I do have some clients that are not. I have some clients that choose to never turn their camera on. I don't school them, but I do think that it is important, regardless of your position, whether you're a lawyer or a plaintiff or a client, a defense client. It's nice to see people's faces. And so I would say you try to keep your camera on as much as possible. What are some of the things that I really do miss? I mean, obviously we all miss handshakes. I'm not sure when we're going to get back to those, but it is nice to go in to the room during an opening and at least try to have some connection to the plaintiff or even the plaintiff's lawyer if I don't know them. Whether it's a handshake, it's a nod. It's hard to do it. It's not impossible, but it's hard to make. It's more difficult to make that connection when you're looking at a screen. Lawyers, but that's just the way it goes, and we have to get used to this because it's going to be around for a while. One of the things that when this started, I was concerned about, and I want to hear from others, I was concerned that there was going to be, because there's an easier way now to just walk out of the room and leave the mediation. Nobody's traveling, nobody is driving downtown, pick your thing, your piece, that it was going to be easier for people to just say, forget it, we're done, we're walking out. I will tell you that in the 22 that I've done, I've never had that. I've never had it. That doesn't mean that they haven't ended without a settlement, but it wasn't that they just got frustrated and just walked out. I've had this discussion, I think with you, Rob, I know with Mike, and it seems like it's just not an issue right now. People are not walking out more frequently during Zoom than in person. So that's something that I don't see happening right now. I guess the other piece I wanted to address was when you get to the end, the terms sheet. It's not terribly clumsy. USA&M has a wonderful program where the document actually can be signed and modified right on the screen, and not a lot of places have that. I forgot what they call that. What is that? PDF readable or something about like that. And it works really well so that you can. What's that, Judge?
Yes, that's correct.
Yeah. So it works out really well where you have the document and you share it and sign off on it, make changes, and it works out really well. So those
Steve,
are kinds of.
Yeah. Can I dovetail on a couple of those points too?
Please.
Yeah, all great points. And, in the beginning, when you're talking about the connectivity and the other things, one of the things that I encounter with my clients is many of them have never used Zoom before, or if they're using them, they're in an area if they don't have that connectivity and that kind of thing. So one of the things that I do is, and I learned the lesson the hard way, is when I have a pre-mediation meeting with my client to prepare them, I do it on Zoom. So that way the mediation is not their first use of Zoom. So we get rid of the things like, oh, I didn't download the app, or I can't get video on this phone, or this computer doesn't work. And it forces my clients to find a place where they can be alone or can think without kids. I have kids in my house and dogs and all that too. And so it forces them to get that process down so that they're not too task loading for the mediation, because they're already going to be stressed for that time. So we do that. I've done that. I do that also with the depositions as well. And then, you know, you figure out the Wi-Fi and those other things. In terms of the other little stuff, like one of the lessons. So right now, and one of the great things about Zoom mediations is that you can do it anywhere. So right now, I have this picture of my office. I took this lesson from one of the mediators at USA&M. I'm not going to tell it. Someone I can say who it is, but he did a brilliant thing, and this is worth the price of admission here. Go take a picture from your desk as if you're sitting at your desk, and then you can choose that as your virtual background, and you can play around with it. And then, so look, I'm sitting at my desk right now, when actually you can do this anywhere. I am in the middle of Texas visiting my in-laws for a week. And I've conducted I've had a couple depots, and I've had a couple meetings, including this. And so play around with this virtual background thing so that you can have that in place. Not that anybody else's background isn't the best either, that's fine. But do around and play with that. The other technological little thing that I've learned is if you're gonna share screen, have it ready to go. Don't hit share screen and then try to fumble around and open up a file and do this and that, especially if you have a computer set up where you have multiple screens like I have in my office, because you'll end up sharing the wrong screen and So I bring up a PDF, like a PDF, ready to go. I have found that Adobe Reader works very well, or Adobe Pro works very well to read. And also Word works very well to read as a Word document. So get those technical glitches out of the way. Now, and then again, you mentioned too, Steve, but if you do have a technical glitch, it's not the worst thing in the world or anything like that. And then you also, and I do that, and then I do the same thing with my clients. I text them or I email them too on the side. The other feature that you want to talk about with Zoom is the chat feature too. So that we use that too, where everybody can read it. I've had but you got to make sure that everybody can read a chat. So I've had mediations where in the chat I've started to discuss confidentiality or something like that, and then we can have a side discussion on that. So the chat feature too can be useful. But I didn't want to interrupt you, Steve, but I just wanted to dovetail on a couple of the technological issues that I encountered as well.
Gary, do you ever do mediations when your client is there in your office, whether they're physically in the room where you are or they're down the hall from you?
I have. So let me answer. I thought of another thing. The other thing is, so I'm a little hard of hearing sometimes. So the thing I do with a lot of my Zooms is I put earplugs in too, to make sure I hear. So never be self-conscious with that, about that. I don't know if people are, but I do have speakers in my office, but the sound there is bad. Yes, I do, Steve, to answer your question. And the times that I've done that is when the client doesn't have good connectivity, or they get on their, and I've had people like literally use their kids' computers, to do Zoom mediations and stuff, and they can't figure out. And so they get stressed out and they say, listen, do you mind if we just drive in your office? And I sure. And then I have them come and either, depending on COVID rates and stuff, I mean, they're skyrocketing right now, but sometimes I'm a little more stressed about it. So I'll put them in another office and set them up. Sometimes I'll have them distance away from me. I have a big office downtown, so we do it there too. So I do it there too. Now, how about you, Steve? Do you ever have your adjusters or your reps in, or are you more virtual now, especially with,
No, I've never been with a client during a Zoom mediation. A big part of that is because all of my clients are out of city, out of state, so they would have to travel here anyway. So that's I've never had a client in the room. I've done a couple of live mediations as a mediator back before the numbers got crazy, but no. The other thing I wanted to go ahead.
Nope, go ahead.
Well, no, there was one other thing I wanted to check and see. One of the other sort of somewhat clumsy thing is when the mediator comes into the room, they essentially have to barge in without knocking on the door. I remember there was some discussion that maybe Zoom was going to add a doorbell. And Rob, you're shaking your head.
I am. A few weeks ago, there were a number of us across the country who were mediators who actually met with the chief information officer from Zoom. And the first comment to him was, can you create a doorbell like the one they do have now when you're the host of a Zoom meeting and someone comes into the meeting for the first time, there's a doorbell, and then you admit them from the waiting room into the main session. So we were assured that they're working on that process. Steve, what I think we have used that works very well is just getting the cell phone numbers of the various parties so that when, as the mediator, we're ready to go in, or more importantly, you know, if Gary's speaking with his client, putting together a counteroffer, when they're ready, they can send a text to me to come back in. And that way we're never interrupting them and we're on their schedule.
Yeah, I've done that before. And you might tell Zoom that there's probably a tech savvy 8-year-old that can design that for them.
So yeah, for sure. So I've had people come back into the room. One of the other things you do, though, that I've always done is I've always tried. We all have good relationships with the mediators, but you have a discussion with the client and the mediator so that they know the process, and so you just be clear about what you want to go into the other room too. I found that a way to address things. Steve, is there any way, I have some answers to this, but to lead off with you, in the mediation time itself, in that mediation, during the Zoom mediation, is there any way that you present your position, ideas, that kind of thing, different via Zoom versus a way that you might hand a photo or hand a medical record to a mediator in times past, and to have them show the other side that you've highlighted or something?
No, I mean, I yell both times, but no, I think, you need to, if you're going to have documents, like I said, you've got to figure out a way that you can, hopefully get them to the mediator in advance. But that's, sometimes they just come up during the mediation and you didn't think about it. But I've had great success with getting the document, emailing the document to the mediator, and then they can use it however way they need to. They can either share it with the other side. I've had circumstances where I've shared it with both the plaintiff's lawyer and the mediator, so that when the mediator is talking with the other side, they both have it up on their screen. It's just, there's a lot of different ways that you can cut it. And I probably have done it, every single possible way at least once.
Can I share with you something that I've been doing too? So
Please.
one of the things that I've been doing is I've been using a Word document that I write during the mediation to set forth different stuff in the mediation that happens, both the offers. See, I would make all these notes in my office, and I'd show the client, here's our demand, here's our office, and they track how it's going. You can figure out midpoints. I'd have highlighted medical records. I'd have different stuff. I'd have the expenses, the liens, and that kind of stuff. But if my client is in rural Missouri or Illinois or something, and I'm in a mediation, I need a way to show that to them. And, and as we know, we're all visual learners, right? So I'm going to share a screen now with some examples, and they're in the written materials about what I do. And I'll just take a minute to explain it, to talk to you about it. And I think I used something like this. You didn't know it, Steve, at the time, but I had a mediation with you where I actually ended up doing this with my client as well during it. So let me share this. So what I do is, so this is an example. This is a during mediation working notes example. So in the mediation, as the mediation is going along, I get the plaintiff's first demand and the defendant's first offer. And then as we're going in, I fill in these numbers as we're going along right here. And that way I can share the screen with my client and the mediator to be really clear about what's going on. And then if there's some other terms that come up, like Steve says, hey, listen, I want confidentiality. Okay, there you go. And then I also do notes about damages. So in this one, there was a difference in the amount of medical. So sometimes I write down what the difference in the medical is, give the exact damages. And then here was this line right here was a difference in a mediation on what the difference between me and the defendant was on the medical. I talk about the issues here: pain and suffering, open and obvious, whether this issue was open and obvious, the problems they had now. And here's something else I did in this one, Steve and Judge, is I took the defendant's the defendant had an IME, they sent it to me, they sent me the report. I took the defendant's report, I cut and pasted it, I copied it from a PDF, I stuck it in my Word document, and while the other side was doing something, I was highlighting all the good stuff for me. And then when the mediator from USA&M came back, said, look at their doctor's report, look how great this is for me. And then at the bottom I did, so then the other thing my client wants to do, and I highlighted stuff, and this doctor was great. He said we needed a surgery that my own doctors didn't tell me we needed. So that was very beneficial. Then I total my expenses because my client wants to know what's going in their pocket. And then the other thing I do is, so this is a during mediation document, is my client's going to want to know where this case is going to settle, what's going to go in their pocket, right? So I'm doing this during the mediation. Listen, if I get them up to 80 grand, this is what's going to be 100 grand, 120. So that the client can see what the fees are going right there. They know what the expenses are. They know what the liens are. And then they know what's net in their pocket. And you'll see these numbers here on the liens was, if I was able to talk, depends how much I can talk down the liens, would inform us as to what goes in their pocket. Let me take you through another one. I got a couple more. You guys can do it. I won't go into the detail I did before, but this is a similar one where we're doing the offer, demands and offers. So we see it. So we see the beginning, what the fee is and the expenses at different levels. So the client knows. And then this one had a big lien. Actually, there was a surgeon's lien for an extra 60,000. So that was in flux. This was my billed versus paid right here. So sometimes I cut my billed versus paid and I stick it on this sheet because everybody wants to know that. Steve wants to know that down the road, and we can compare our billed versus paid or our paid or whatever. And then this is my notes about what the defendant's arguments are, and then I would add images, I would add videos and stuff. Here's another. This is an example from a wage and hour case that I mediated recently and I just settled a week or so ago. This is for overtime, in an overtime employment case. And then, so I would literally cut and paste to give them in this document so everybody can see how I calculated it. This is some examples from a nursing home case that I had where the defendant, the mediator came back to me and said, here's some defenses. And then I wrote in red my responses to them, because I wanted to make sure the mediator got it. Because remember, we're talking about communication. I can talk a bunch. I could talk really quick if I want to and do all that, but we want to make sure it's gotten and communicated to the other side. Good mediators sit down and say, now, what do you want me to tell them? What's your position? And this is a good way to stick this to. And I actually cut and pasted this and I emailed it to the mediator in time. Then I also went into a deposition. There was an issue. I went to a deposition. I literally cut and pasted from the PDF of the deposition a good answer that I thought was a good answer to try to communicate that to the other side. So again, what I do, and there's no magic about this, what I do is I create a Word document and I make myself work during the mediation in the in-between times when the mediator's talking to the client or I'm talking or the mediator's in the other room. I am sitting here and I'm trying to organize the thoughts and organize stuff because, you know, Steve, we've done this ain't our first rodeo. We've done these enough that we kind of know what's going to come up next. And then if you're like me and you play the game of where you try to guess what the other person's next number is, then I type it in before I see how close I get. I do that too. So it's a way, and I find that the clients find this very useful if they can see this in front of them too, because people forget the numbers. It's hard to do the numbers. You and I, people who, the mediators and the lawyers who do this all the time, this is very easy for us because we're used to taking what's our fee, what are expenses, and then you're saying, well, the liens are this, but if I negotiate down, it's this, da, da, da. So this can be easier to us than I find that it can be to my clients. So seeing some of that. And then it's really great. One of the things, then it's really great if I settle the case, we do the release, I get I put the money in my trust, and then I send them the check with the settlement statement. And they're like, you know what, that's really darn close. In fact, you're putting more money in my pocket than you said you would at the mediation. So it's another way to address expectations with clients. The reality of, well, you said you're selling for 400 grand, but I'm only getting this in my pocket, some of those things. So it bridges those gaps too. So that's one of the things that I've done, Steve, to try to, I don't know, but do it a little, to have something more concrete in front of someone on a video.
Do you all take a different approach with your pre-mediation submissions in a Zoom versus an in-person mediation?
I don't. We like I said, we talk the case, we report on the case. There's multiple conference calls, and it's the same whether it's in person or Zoom.
I do, Judge. The main thing, there's a couple of main things I do. One is that I give everything to the other side even earlier than I used to. I think 10 days or a week before. I want them to have everything, because it's harder to get insurance adjusters or committees or whoever they're going to get more authority if I'm just handing them 5 or 10 grand worth of wage loss during that, or an extra surgery bill or this or that. So I want to get it all to them, because if for instance, if Steve sees something in my pre-mediation statement, he says, Gary, I need to go depose this doctor because I ain't going to pay you for it unless you do it. Then we kick the mediation for a month and a half or something. So I do that. The other thing is I have this form email where I tell my clients, I didn't have that before. I would do it more orally, and I would have more time during the mediation to teach them about mediation during the mediation. I try to do it before so they don't feel as rushed or pressured during a mediation. They're under the hot seat a little bit, so they can have so they can understand their, just dealing with their expectations. So that pre-mediation, those are the main things I do. Oh, the other thing is I do also work on my liens before the mediation. I've always done that, but I'm a little even more focused on that now, because even though so that's what I do. And a question, because Steve, has doing these mediations made you, I don't want to say this harshly, less cheap?
To you, Steve?
Me personally, no.
No, with your client, I'm just trying to be funny, but I mean, it's not going to change the price. So sometimes I work on my liens even more to settle a case, I guess was the kind of the point.
I mean, I will say the pandemic, I think, which is a different topic, but I think the pandemic has made for settlements that you wouldn't necessarily be getting them for those numbers pre-pandemic. Judge, I have a question for you.
Yes.
As a mediator, the hardest part for me is making that connection with the plaintiff by Zoom. What is your experience? Do you have the same thoughts? What do you do to get around it? If you could, comment on that.
I agree. It's more difficult through Zoom to make that human connection, which I really like. But oddly enough, I've gotten this wonderful thank you card from a plaintiff in a case that I mediated and settled, that I never thought would ever send me anything. And I thought that they were probably upset with the result, but I wound up getting this, thank you very much. We knew that you listened to us. And I think part of it is being a judge and being a mediator is we've got to use both of our ears all the time and really be listening with mediation. Before we were in person, we'd pick up body language, and we can't do that as much as we do in person mediation. So I'm really listening very hard. and trying to make that connection. Because what people want is just your undivided attention, my opinion. And if you're
Judge-
giving them that and they feel that they're getting that, then they're okay.
And so you, Judge, is there anything you do similar to Steve's question? Is what do you do differently as a mediator to try to have that connection or to get through either directly from the mediator or build a bridge between the defendant and the plaintiff?
That's harder to do through Zoom. I admit, I try to start with, we're all here today with a common purpose. And that common purpose is because each of you believe that this case can settle. And so we can all agree we're here for that reason. And so I try to build a bridge between them. We're all here to get here for the same purpose and to work toward the same goal. How we get there may be a little messy, but we'll hopefully get there. And so that's what I try to do, is find commonality if I can.
Yeah, I think, when I'm mediating cases, I feel as if I'm spending more time talking with the plaintiff in a Zoom mediation than I would during a regular one. A lot more of getting to know them, a lot more of the, how are you doing? How are things? Work, children, are they in school? Are they Zooming? Just to try to break through that one-dimensional screen that we're forced to have to deal with.
Right. Because we're all human beings. It's the end of the day. And so you do try to touch upon something that's human and that we can all relate to.
Steve, can I ask you, when you made that comment before in terms of cases settled and you didn't think they would settle the levels, what can you be more clear about that? Is that better for me or not better for me?
Well, it depends on how you define better. If you
For my
define,
clients,
getting,
of course.
yeah, well, I mean, if you define getting a settle, I mean, let's face it. I mean, and this is probably getting off the topic, but maybe it's not. We're not going to see civil trials in this community for a while.
That's where I was
Not
going
gonna
with this question.
Yeah, not going to happen in the city, not going to happen in the county. I really question whether we'll have them. Maybe we'll have them in the second half of 2021. I don't know. So, so I see a lot more mediations, although I tend to mediate a lot. But I also see, unfortunately, people that are hit by the pandemic hard economically, and that's what I meant by that. Is I do see cases that are settling for less than they would have settled pre-pandemic because people need to move money.
And that was going to be a question I was going to ask the judge. Judge, so one of the things that my threat against Steve's clients is a trial. So now we don't have that. So right. Steve's question to you was connecting with the plaintiff and challenges in that. My question to you is, how is the lack of a threat of a trial affected? That's my pressure point on the other side. How are you dealing with that on the other side?
When is your trial going to be? What century? Right now. You can threaten them with a trial, but when is that going to be? And how much more money are you going to throw into this case in the meantime? And so that's my pressure point. I wanted to share with you all too that I did have a group that wanted to come in during COVID-19 and wanted to wear masks and be socially distanced. All I could see were people's eyeballs. And it was very difficult to do, and it was unsuccessful because I knew the minute I walked out of the room, they're taking the mask off. So we're not getting a whole lot of benefit from the mask anyway, because all the particles are in the air. And all I could see were people's eyeballs. And so I have found Zoom to be much better than doing it in person with mask on.
Thank you.
Yeah, I actually had an arbitration that was set for this week. And we had that issue that we were dealing with, which is what you just described, Judge, which is some people that wanted to not have the masks on, and some that wanted them on. And then you have to add to it, the hearing issues, and some people have better hearing than others. What we're going to do, we have a very large courtroom here in our office where we can have 4 people in there and be very well socially distanced. And I've done that with mediations where the room was big enough. I felt comfortable that we could do the mediation and have the masks off. That's very, very uncommon. And frankly, I've only done that once since it all started.
Yes. Yes. I much prefer the Zoom than having people masked up, and that's even getting less body language back to me in terms of how somebody's feeling about something. It's harder to bridge that gap even more.
Right.
Oh, I think we have maybe a minute left. Rob, do you have anything?
A couple of things that have come to my mind just based on a number of cases that I've had, especially 2 this week, where we had a Zoom mediation. I had the client, the plaintiff with plaintiff's counsel, and it was a pre-suit case, and we had a situation where the camera was on the lawyer and the camera was not on the client. And I had the defense lawyer seeing the plaintiff for the very first time, who presented very well. And frankly, I asked the plaintiff's lawyer, could you change your camera angle so that the defense lawyer during a joint session could see the plaintiff? I had a worse situation where I had a plaintiff hook in by his cell phone. He took the phone, put it on a table, and I saw the ceiling fan the whole time. And frankly, the worst situation was where I had plaintiff and plaintiff's counsel in a room. They had it on an iPad, and they were both wearing masks across the table from one another. And the camera and the monitor was facing the lawyer. So the client couldn't see the other side. They couldn't see me. They could not see my facial expression. And there's so much of the challenge of dealing with the nonverbal and how important that is. The one thing that Judge Reel and most of us are doing are spending time in an initial caucus with the plaintiff and plaintiff's counsel. Mm-hmm. And in terms of just process, telling the defense lawyer, don't even dial into the Zoom for 15 or 20 or 30 minutes, depending on the case, so that we can have sufficient time. And it does take longer to gain that trust and learn the bits of information, Steve, that you were talking about, are they dealing with having to sit with kids, et cetera. So those are a couple observations that I've had.
In a perfect world with time, when I'm the mediator, I try to have a short conversation with each of the lawyers or all the lawyers before the mediation to just talk through some of those logistical cameras, where people are going to be things.
Yeah. Well, Gary.
Go ahead, Judge.
No, go ahead, Gary.
The connection between the plaintiff and the mediator is so crucial. Having a good connectivity, having them being able to relate, having them to be able to interact. I tell my clients all the time, listen, they can hear from me, but they hear from me all the time. They don't want to hear from me. They want to hear from you, because when the better settlements I obtain, or the better results, are when the mediator really connects with the client, and they really the mediator really gets what the case is about, and then that mediator is able to go to the other side and say, this person's going to be a great witness to trial. They're a really good person. They're not blowing smoke. They're not exaggerating. This is the real deal. This is a good settlement. And then the mediator wants to go to bat more for your client too. Not that they want for every case, but they really feel for it, and they can feel it. I've had some mediations recently where the mediator is really connected with my people. And I tell my people that, I say, listen, you guys got to not play the mediator, but you have to connect with the mediator, because that you want them to be your advocate in the other room. So that kind of touches on Rob's point.
Okay. I'd like to thank both Gary and Stephen. You had a wonderful presentation and enjoyed it. I have one final tip to everybody. Please don't be a Jeffrey Toobin, and keep your privates private. As a final tip from your moderator. Thank you.
Judge, thank you. Gary and Steve, thank you both. We'll take about a 6-minute break and get started at 3:30 Central. Thanks so much.
Thank you.
Stay safe.
Thank you.
everybody.
On the record button. There we go. So Mike's practice is primarily in the area of insurance coverage and bad faith, and we'll be taking the position from the insurer's perspective. Seth Lambden is joining us from Chicago, who practices with the Neil Gerber Eisenberg firm, joining us to talk about his perspective in representing policyholders in these types of disputes. Both are very experienced in the area of coverage. Seth, graduate from Brandeis, and John Marshall in Chicago, and Mike, graduate from Wash U, and then went on to St. Louis U. Both are really experts in their field, and if folks want to stay current, I would suggest you connect with Mike Young on LinkedIn, because he posts almost every day with tidbits and sometimes copies of decisions or other information in cases. So without further ado, Seth and Mike, please take it away.
Thanks. Hi, everyone. Just by way of quick introduction, my name is Seth Lambden. As Bob mentioned, I've been practicing insurance coverage law for the past 20 years, focusing exclusively on representing policyholders. So what I'm going to be talking about today are, my perspectives, my thoughts on what we've seen so far in the COVID business interruption litigation, where I think things are going. And, I think circling back a little, to the last program on mediation, I think a key takeaway here is, anyone that tells you that these claims are absolutely not covered is doing you a disservice, and everyone that tells you that all of these claims are covered is also doing you a disservice. The fact is, both policyholders and insurers have litigation risk, and that's what we're going to be talking about today, sort of the framework for evaluating those claims and giving sort of an update about where we are. Mike?
Good afternoon, everyone. As Rob said, my name is Mike Young. I do insurance coverage work at Hepler Broom. That's why I've been given the nickname Mr. Excitement. Obviously, I do usually liability coverage in Missouri. That's why I'm losing most of my hair. But we also do some first party stuff as well. And obviously that's what this is about. Seth has said, if anyone tells you that these claims are not covered, they're doing you a disservice. Well, they're right, but they still may be doing you a disservice because the courts around the country have largely ruled in favor of the insurance companies, but not completely. Particularly in the state courts where it's more of an even draw. So we'll go through these sorts of issues and kind of break down how we see it, and I'll explain how I see it from the insurance company side. I know Seth put together some written materials for the CLE here today. They are excellent. They're not correct, but they're excellent writing and certainly advocates on behalf of the policyholder. So I'm thrilled to be able to go over these things with Seth here today.
Okay. Mike, next slide. All right, so I see we've started early in terms of the dispute. Let's start at the beginning, though. When we're talking about business interruption coverage, Mike, can you go back one? Oh, there. Next slide. Thanks. When we're talking about business interruption coverage, what we're really talking about is a type of coverage that is provided by many, but not all, property insurance policies. And putting aside the COVID pandemic for a second, I think how you best sort of understand how this business interruption coverage comes into play is, in the instance of a catastrophe or a fire, and you have a business that is generating revenue, a fire damages the property, rendering it unable to be used. The period during which the business is being restored, being repaired, rebuilt, et cetera, is the period during which this business income coverage comes into play. And that obviously doesn't completely fit the framework of the COVID pandemic, but the analysis is really the same. So let's start with the beginning. What we have on the screen is an example of a business interruption insuring agreement in a policy. Now, this language is representative of many policies out there, but it is by no means the only language that is out there. And just like any contract claim, you really need to focus on every word in the policy. Don't assume that they are the same, et cetera. I have some clients advancing very different arguments based on just a word or two in the insuring agreement or other parts of the property. Mike, next slide. So there are really three key elements that the policyholder has to establish under a property policy to trigger this business income or business interruption coverage. The first is there needs to be a suspension of operations. And I should say every one of these terms are things that Mike and I are going to be talking about today. There is not uniformity of thought in the case law. There is not uniformity of thought amongst the plaintiffs bar that are bringing these claims. There is not always uniformity, but there is more so in the insurer bar in the insurance industry about these concepts. And what we are also seeing is a whole bunch of different approaches that policyholders and courts are taking to evaluate these three concepts. And it's sort of a laboratory right now. People are seeing what works and what doesn't. There are attorneys like myself who have clients with fairly large business interruption claims that are sitting back and waiting to see what works and what doesn't. My clients don't necessarily want to be the guinea pigs, and some of them can afford to wait it out, some can't, but that's how they're sort of viewing these issues. But in any event, these are the key elements: suspension, direct physical loss or damage, and a covered cause of loss. The last piece I'm just going to touch on briefly. Most, but not all of these policies are all risk policies or special risk policies. And what that means is that these policies cover losses for any type of physical loss or damage that is not expressly excluded under the policy. That becomes a much bigger issue when you start down the road, especially to the extent you can get one of these cases to trial. As an aside, the first COVID case will be going to trial in New Orleans starting early next week. The judge has denied the insurer's motions for summary judgment. There's no virus exclusion at issue in that case. I don't know what to expect. I think the policyholder's chances are very good. It's sort of an interesting aside. Quite early in the pandemic, I had the good fortune to listen to a jury consultant who had done some polling of prospective jurors. And I don't remember the jurisdiction. It doesn't really matter. He had some very interesting insights though. And his view from a policyholder standpoint is get these cases in front of a jury. Jurors are going to be sympathetic to business that are incurring business interruption losses. They are going to be far more likely to set aside policy language if that's necessary to do what they consider to be the right thing. Anyway, just sort of, again, I thought that was an interesting aside. Whether that's accurate will bear out, and clearly it's jurisdiction specific, et cetera. Mike, next slide. So just really briefly before we get into the key issues, this graphic on the screen outlines sort of the typical timeline for a business income claim or business interruption claim. So to the far left of your screen, covered physical loss or damage. In my prior example, we're talking about when the fire strikes, when the hurricane hits, et cetera. Today, we're going to be talking about something different. We're going to be talking about whether it's the presence of the virus, SARS-CoV-2, the presence or imminent presence of people that have COVID-19 entering and going near the premises, whether it was the government shutdown orders that precluded some businesses from operating in whole or in part, or whether it was something else. Does that constitute covered physical loss or damage, or is none of it? That's what we're going to be discussing. But so what happens on day one? We've got the covered physical loss or damage. Now, if you're used to handling property claims or liability claims, but have not had the opportunity to work on a business income claim, when you think about deductibles, you're probably thinking about a set monetary amount, $10,000 deductible, and then coverage kicks in. For business income, it's a little different. Instead of a set dollar deductible, it's usually a time deductible. So you might have a deductible of 3 days of business interruption losses before the coverage commences. So let's just say we do have 3 days here, time deductible. The green period is the period during which in the fire example, the building is being restored and it extends to the point where it reasonably should have been restored. In the COVID example, again, that's a little bit different. We're going to be talking about that today. And then the last piece, when it ends, it's either a policy limitation or more often it's the date on which the property was or should have been restored to its pre-loss condition. And for our purposes here, I just really view it as generating revenue. But Mark, why don't you start by framing the issue? Because the key issue I want to really focus on today is the concept of direct physical loss.
Right. So direct physical loss is really one of, if not the key issue in all these business income loss claims. These policies are very, all this is going to be decided largely by state law, and it's all policy by policy, and the language can differ. And if you look at these cases and the decisions across the country, it's amazing how similar yet different, in subtle ways that the different policies are. Like just like one quick example, we talked about how there needs to be a suspension. And in the sample language we have here, we see that suspension is a defined term. Usually you don't have to have your business completely shut down in order for business income coverage to kick in. But there are some older policies floating out there that don't define the word suspension. And there are some courts that say the business has to be completely shut down in order for BI coverage to kick in. So there's just little wrinkles like that, throughout all these different claims. But, the big issue in that we see so many times is we have to have direct physical loss or damage to property or of property. And, what does that mean? From the insurance company's perspective, it's sort of the, the kind of claims that Seth is talking about, whether it's storm damage, lightning strike, flood, tornado, hail, whatever kind of covered cause of loss it is, actually, physically damaging, physically, like we have here, permanently altering the property, that's simply not being able to use it, not being able to, access it or et cetera, is typically not supposed to be what direct physical loss is. That's at least the insurance company's perspective on it. Obviously, some policyholders and a number of courts disagree with that. So trying to get our hands around what exactly is direct physical loss is in so much of the way what we're really talking about here for all this stuff, because again, when we're talking about these COVID claims, we have restaurants, bars, doctors' offices that either shut down or significantly, reduce their operations, because the government told them to, or they didn't feel safe or whatever, is simply, not being able to use the property because of shutdown orders or because, someone was on the premises that was sick with COVID-19. Is that enough to meet this requirement? And there are, a number of cases that have come up across the country, not too much from Missouri, but I would fairly say that most of the cases that came up before this issue on the whole said that you need to have at least some physical alteration of the property in order for, business income coverage to kick in. The Source Food case from the 8th Circuit, it's from the 8th Circuit, but it's applying Minnesota law. So for the Missouri lawyers, it's interesting, but not super interesting. It was a case where it was an importer of some food, and due to mad cow disease, they were trying to import it from Canada, I think. Through the mad cow disease epidemic, the United States wouldn't allow this beef to come into the country. And the claim there was, well, we had some loss of use of the property, and therefore we should have some business interruption coverage because we have direct physical loss of the beef itself. And the court there said, no, you have to show that there was some actual contamination of the property in order for there to be coverage, and there's a number of other cases there that do a similar analysis, and the cases are really, there's just different variations, but it's always about having some kind of physical alteration or physical impact. And the idea is if there's some kind of, disease or dust or whatever that gets on property, but it can be cleaned off, that's not direct physical loss. So just to kind of run through these examples, that the Mama's Joe's case was a restaurant where there was dust and debris from nearby road work. Court said that's not direct physical loss because the dust can be cleaned off. You have that lightning rod mutual case. This was one where there was some mold on the property. The court said, well, you can just clean the mold off. There's no direct physical loss there. The universal image case, more mold bacteria in an HVAC system. Again, clearly you can't use the HVAC system. The place is shut down for a period of time, but if it can be cleaned out, that's not physically altering the property. And the court there said no. And in fact, this, Benjamin Franklin case was one where he had asbestos contamination in a building. And so you would think, my goodness, there has to be some physical alteration there because we have asbestos fibers and so forth in the property. The court there said no, because the property, the building itself remained unchanged. You could just take some of the stuff out, the insulation or whatever, and there's no physical loss. So, this is, the cases that the insurance companies will often cite, and there's dozens, if not hundreds of others that sort of take this similar view. Of course, there are courts out there that don't see it this way.
Thanks, Mike. All right, so I was just trying to see if I could share the screen here. I think I'm buried behind some slides. Anyway, you might notice that Mike and I have been talking about the concept of direct physical loss or damage as if it's a singular notion. We're using the phrase, it's just taken right out of the policy. And the insurance industry's position is that direct physical loss or damage, really a singular concept in their mind, requires a tangible physical alteration of the property. And, if you're talking about a fire loss, and I'll keep coming back to those examples just because I think they're easy to understand. Yeah, sure, you have direct physical damage. But what I think is really the key argument, and I think it's the stronger policyholders argument, and I'm going to be discussing some cases later in which courts, including the learned Judge Boo, agreed with this analysis, is that the presence of the word "or" renders this phrase disjunctive. It's direct physical loss or direct physical damage. And, it's not just an insurance policy rule of construction. It's really any rule of rule of construction for any contract, which is you give every word meaning. You try to interpret phrases and words such as they're not deemed superfluous. So let's say that the term direct physical loss is something different than direct physical damage. That's the policyholder's position. And that is not a position without some support in the case law. And I have on the screen 3 examples of cases that were decided before the COVID pandemic. They have been cited frequently by policyholders in the COVID business interruption litigation. And the concepts in the cases themselves are getting some traction with the courts. So the first one that I'm going to take them a little bit out of order, the total intermodal case. I'm not going to go through all the facts of that case other than to note that this is a property damage case in which the insured's cargo was lost as it was being shipped to China. The insured had a property policy that provided coverage for, just like the policies we're talking about today, direct physical loss or damage. Insurance company's position is, well, your cargo wasn't damaged in the sense that there wasn't a direct demonstrable physical damage, therefore there's no coverage here. The court didn't agree. What the court held is if the court took the position that direct physical loss and direct physical damage were really synonyms, it would render meaningless the or damage portion of the clause. And according to the court, thereby violating a black letter canon of contract interpretation. So that's a case that really just sort of recognizes this framework. I think you'll see that the next couple of cases, though, present facts that are actually more akin to the COVID-related losses. So one case that has been cited quite frequently is the Gregory packaging case out of the District of New Jersey. Now, that was a case where the insured was a packaging facility. There was an accidental release of ammonia into the facility that caused the facility to be shut down for a week while the ammonia was being remediated, while it dissipated. While the ammonia was in the facility, it could not be used. It wasn't a complete destruction of the facility. In fact, they hired an outside consultant to wash down the facility with water. to clean it up. Made a business interruption claim on their policy, claiming loss of revenue for that week during that they were down. The insurer denied the claim, saying there was no physical loss or damage here that caused the facility to be shut down because the ammonia dissipated. All the facility had to do to remedy that problem was air out the property. If that sounds familiar, it's because it's an argument that the insurers are making today in connection with COVID, saying, well, there's no loss or damage. The court disagreed. And I'm going to just, if you indulge me, just quote from the case. What the court held was, quote, while structural alteration provides the most obvious sign of physical damage, property can sustain physical loss or damage without experiencing structural alteration. And what the key there was not whether there was a physical alteration, but was the facility rendered unsafe for safe occupancy? Was the insured able to continue generating revenue on the property that was insured? The answer was no. The court found that business interruption coverage applied. The Oregon Shakespeare case, another one that it was vacated by settlement, although I don't think anyone is really viewing these cases as precedential. I mean, they're often unreported District of United States District Court opinions, but because there is such a dearth of case law due to the unique circumstances, policyholders are citing cases that are factually on point, and courts are looking to those without question. But the Oregon Shakespeare Festival, this was an outdoor open air theater festival that had to curtail their performances for a week due to smoke from a nearby forest fire. It's not that the theater burnt down. It's not that there was any sort of physical damage to their facility. They couldn't run these outdoor plays because there was smoke. They had to wait for the smoke to dissipate. Same claim, business interruption claim, same arguments that we heard from the insurance company. No physical demonstrable loss, therefore no coverage. Court disagreed again and said that you have a situation where the loss was the insured's inability to use their premises for safe purposes. And this wasn't just a mental or emotional loss. It wasn't a theoretical loss, but it was a physical loss. They were unable to use the facility. So I think you can see just sort of from those factual descriptions, there are cases that have some analogous facts to COVID, and there are others out there as well. There's a case out of the 8th Circuit where a spider infestation in a house was deemed to constitute physical loss, even though, of course, the spiders could be exterminated and removed. There are plenty of cases out there where courts have found that the discharge of friable asbestos fibers into the internal atmosphere of a building constitutes physical loss. And I'm not suggesting that the fibers that are encapsulated in the insulation would fit the bill, but the discharge. And so those are the cases, and there's others out there. There's a list cited in my paper, and even that list is not complete, of cases that policyholders are going to be drawing from, and we're going to be asking courts to follow. But let's switch gears a little bit, Mike, and talk about what we're seeing post-COVID.
Yeah, it's interesting because the cases that we're talking about, whether it's these insurance company cases, which I think are probably the majority rule in a lot of jurisdictions, or the cases that Seth talks about here, you try to more coverage friendly decisions like this analysis. Do we have to have actual physical alteration of property versus this sort of loss of use or loss of access of the property? These kind of philosophies or what we're seeing play out in the decisions in the COVID context. It's sort of these different philosophies are just being applied to the different facts in these cases, or at least in the complaints that have been filed and alleged. And in most of these cases, we're at the, that we'll talk about here are motion to dismiss cases where the court either did or did not grant a motion to dismiss. There have been, like I said, probably, and if anyone's interested, I know there are always charts floating around where there are people that track these things. I think there's almost 900 different lawsuits that have been filed across the country on these types of claims. And I think the last count I saw, it's about, 60 to 15 or so in favor of the insurance company and against the policyholder. So, but again, most of those have been in the federal courts. And here's, 3 examples of them, this Sandy Point Dental case, the 10E versus Travelers case, and this Turek Enterprises. These are not necessarily the leading cases, but these are 3 of the 50 or 60 or so that have addressed these issues, particularly on the direct physical loss side. And what we see in these, it's the cases pre-COVID, do we need physical alteration or not? That is really kind of the key issue in these cases. And some courts say yes, and some courts say no. So these are 3 cases where the court has said you have to have these. So the first one there, that Sandy Point, the courts, this was obviously a dental office that was largely closed during those early months when we were all kind of shut down. And the argument there was, well, COVID-19 is everywhere. We have these orders shutting us down except for certain essential services. This dental office argued that they weren't subject, allowed to continue to practice because the dental practice that they engaged in sort of ordinary procedures. And so they said, look, we were shut down, we lost income, we should have coverage for that. And this is a Northern District of Illinois case up, where Seth is. And the court here said the critical language, direct physical loss, unambiguously requires some form of actual physical damage to the insured premises to trigger coverage. The words direct and physical, which modify the word loss, ordinarily connotate actual demonstrable harm of some form to the premises rather than forced closure of the premises for reasons extraneous to the premises themselves. Court goes on to say plaintiffs simply cannot show that any such loss is a result of the inability to access its office or the presence of the virus on the surface, the latter of which the plaintiff fails to allege in its complaint. Plaintiff has not pled any facts showing physical alteration or structural degradation of the property. Nothing about the property has been altered since March of 2020. Plaintiff did not need to make any repairs or change any part of the building to continue its business. So again, the focus is on, is there any physical alteration here? And the answer is no. So the court there saying there's no coverage. So then we take a look, at this 10E case. This is a restaurant, I think, in the California area, filed this in the Central District of California. And it sort of very simple, a similar holding from the court there, that direct physical loss within the meaning of that term, you have to have a distinct demonstrable physical alteration of the policy. Detrimental economic impact doesn't apply, and it was, this one's kind of funny too, because the court said the insured cannot recover by attempting to artfully plead impairment to economically viable use of property as physical loss or damage to property. They don't understand in Missouri, artfully pleading to try to get coverage is sort of a local tradition, but I said the court wasn't buying that in this Central District of California case, and like the other case, they don't allege that that the virus infected, stayed on the surfaces, or could it be cleaned off. So that's similar to the pre-COVID cases too. They didn't allege that the virus was on property, but even if they did, that there's nothing there that stayed on the surface, couldn't be cleaned off, couldn't be gotten rid of. So again, this is a very, very similar type of analysis. And there's a lot of cases like this, particularly from the federal courts, that have said, if there's no physical alteration, which simply, being shut down because of government orders, or even if someone's on the premises that's sick, if that doesn't physically alter the property, there's just no coverage. And the last one there that I cited, this is a little interesting because this case out of the Eastern District of Michigan, it was, I think, a chiropractor who alleged that, that their place was shut down due to different shutdown orders and due to the pandemic. And the court there honestly sort of applied a Missouri type analysis, if you will. Missouri, in my view, more times than not, when they're interpreting policy language, don't necessarily look at the intent or the purpose of the policy language, which you may see in some other states like Illinois, but they're really interpreting the language at times super literally. That's kind of the approach that this Michigan court took on the case, because the language there in the policy said there had to be direct physical loss to covered property. Okay. Some of these policies will say that there has to be loss or loss of or damage to property, but this one just said physical loss to the property. And the court there said, well, since they used the word to say that simply loss of use of the property would get coverage didn't make any sense. You know, the court said that this language requires that there be a loss to the property, not just any loss, a direct physical loss. The court interestingly said that the argument, though, for coverage could be plausible if the term at issue were accidental direct physical loss of covered property. You know, and I think that you see that in the case that or two that Seth will talk about with Judge Boo. So, you know, the different approaches, even, you know, the Missouri type analysis where we're interpreting language super literally, so far, for the most part, has favored the insurance company side of things here.
So now I'm going to talk about a few cases where, at least for purposes of a motion to dismiss, the policyholder prevailed. But I do want to put these cases in context, lest you come away with, from this discussion, thinking that there are always clear-cut paths to victory here. That's not really the case. So a lot of the cases that were filed, and as Mike said earlier, I think there have been over 1,000, probably now 1,005. They're probably being filed every day. They contained exclusions for viruses that were quite broad. So when faced with that exclusion, policyholders tried to plead around it. And a lot of them pled that there was no virus on their premises. There was nobody sick on their premises. And as a result, they often were, the motions to dismiss filed by the insurers were granted. So we're going to talk about the exclusions quite briefly, just because there's a lot there and we're limited in time. But I do want to note that the cases I'm going to be talking about either did not have virus exclusions or they didn't come into play in the decision. And I think the ones I'm about to talk about did not have virus exclusions, because right now we're talking about what the insured has to show to get within coverage. If the insured makes the physical loss or damage showing, then the burden shifts to the insurance company to show that an exclusion eliminates coverage. And in this context, that's typically going to be a virus or, according to some insurers, a contaminant or pollution exclusion. So the reason I mentioned that is because the Studio 417 case, again, was a motion to dismiss. The case was brought by a group of hair salons and restaurants. What they had in common was they were all unable to conduct business operations as before the loss due to shutdown orders in Missouri. What they alleged in their complaint, and you know, some policyholders have done this, some haven't. It works in this case. What they alleged is that it is likely, that was from their complaint, that employees or customers who were infected with COVID had come onto the premises, therefore leaving the virus SARS-CoV-2 on the premises. They alleged that the virus attached to their insured premises and deprived them of the use of their property. The insurance company denied the claim for reasons that by now we're probably, you can expect, which is direct physical loss requires, this was the insurer's formulation of the standard in that case, quote, actual, tangible, permanent physical alteration of property. Just like the total intermodal case that I mentioned earlier, the policyholders counsel in this case focused on the use of the word or. Direct physical loss or damage, disjunctive, means two different things. The court took an approach that I think was actually quite interesting, and it's appealing to me really because of its simplicity and the fact that it does track established rules of contract and policy construction. The court first looked to the policy to see, well, is direct physical loss defined in the policy? No, it was not. You will not find a policy that has an explicit definition, most likely. Well, then the court said, well, what about the constituent words, direct, physical loss? Are they defined in the policy? And they were not. So, you know, under Missouri law, no different than anywhere else, a court interpreting an insurance policy is required to give the policy terms their plain and ordinary meaning, not technical terms, but how a reasonable policyholder would view it. So the judge pulled out the Merriam-Webster dictionary and looked up direct. And found that the definition was, in relevant part, characterized by close logical, causal, or consequential relationship. Then flip to the P's, physical. Found this definition, relating to material things that are perceptible, especially to the senses. And then loss, the act of losing possession. So what did the court do? The court looked at those definitions and concluded, well, the virus is a physical substance. The plaintiffs were deprived of their property, the use of their property, because of this physical substance. And also stated this isn't just economic harm. According to the court, the plaintiffs were prohibited by those government orders from using their premises. The court did recognize there's a split in authority, which I don't know whether it's. I know that Mike doesn't agree with it, but my view is that as these courts diverge in their interpretations of direct physical loss, the policyholder's argument that that phrase is ambiguous and therefore must be interpreted in favor of the policyholder grows. But in any event, that's how the court looked at it. I'm going to skip to the North State Deli case because I think the contrast between that and the Studio 417 case is actually quite interesting. As an aside, I was surprised to see this case because I am helping out a client in North Carolina, and doing my research, I had found that on April 17th, the North Carolina Insurance Commissioner had posted something to their website basically stating that pandemic-related losses are not the kind of risk that's designed to be covered by a property policy. Now, that's not binding, it's not precedential, but it was out there. So this case was brought by a group of insured restaurants. They, just like the restaurants and salons in Studio 417, were subject to shutdown orders, stay-at-home orders, impaired their ability to use their restaurants. Now, most of these orders, I think, in North Carolina were precluded in part from using their restaurants. The dine-in facilities were shut down, but the takeaway and delivery services were allowed to proceed. But this judge, just like the judge in Missouri, pulled out the dictionary, used the same definitions as the judge in 417, but found that direct physical loss, in his view, describes a scenario where business owners lose the full range of rights and advantages of using or accessing their property. So the court found that the shutdown orders, not the presence of the virus, which is what was alleged in Studio 417 in that case, but the shutdown orders resulted in the immediate loss of use and access of these insured properties without any intervening conditions. So as the court concluded, and I'm quoting from the decision now, in ordinary terms, this loss is unambiguously a direct physical loss, and the policies afford coverage, end quote. Basically, what the court was saying is when an insured is forbidden from using property for income generating purposes, or safely, I should say, that's physical loss. Now, the distinction between North State Deli and Studio 417 is interesting from a procedural point as well. And it does, I think, put policyholders perhaps in a bit of a conundrum, but 417 was a motion to dismiss. In that case, the insureds alleged that COVID or the virus SARS-CoV-2 was on their property. Are they going to be able to prove that at trial? I don't know. My view is probably yes. I'm looking at similar cases. I'm talking epidemiologists and statisticians and folks that would show that it's more probable than not, more likely that there were folks with the virus on the premises, thereby depositing it. But this is really, in Missouri anyway, that's table stakes. Alleging the presence of the virus was really what was necessary to get through the motion to dismiss. And as Michael was saying, plenty of courts have granted those motions to dismiss. The pleadings were a variety of different arguments, but that's the same. North State's different. So that case was summary judgment. It's being appealed, but the insured won. And the court did not focus on the presence of the virus on the property. The court focused on the shutdown orders. So you can see two almost identical analyses, same dictionary, same words, same definitions, similar facts, but the way that they were pleaded were quite different, and the ultimate conclusions were quite different. Does that mean in North Carolina that a claimant that alleges the presence of the virus on their property constitutes physical loss? Of course not. But it's certainly, the corollary is not necessarily true. It remains to be seen whether in Missouri, alleging the fact that a shutdown order caused the loss, even though it was the result of the pandemic, is covered physical loss or damage? We don't know the answer to that. So anyway, it's just sort of an interesting issue. I don't want to take up too much time. The other two cases that are on the screen are sort of representative of the cases that are holding that loss of functionality, the loss of use of a business function, the inability to use a business for its safe purpose, income generating purpose, is can be covered loss. And I need to keep catching myself because, again, these are motions to dismiss. There've been one substantive ruling, and it's the North Carolina case, as far as I know, one substantive ruling, the North Carolina case. And then the urogynecology case is sort of interesting because while the policy itself was not before the court found that it was not clear that a virus exclusion was designed to apply to pandemics. And there's a lot buried in that, but it's just sort of interesting to me because there's this idea out there that a quote unquote virus exclusion ends the game for a claim. And my response to that is really twofold. First of all, that's not what every court is saying. And second of all, and I think more important for those of you who are counseling your clients or evaluating cases for mediation or ruling on them, et cetera, is that it's dangerous for a policyholder to use the term virus exclusion because there are a lot of flavors of exclusions out there. Some use the word virus, some don't. Often what you're hearing about is the exclusion that was promulgated by the Insurance Services Organization, an industry that serves a group that serves the insurance industry, which is quite broad. But there are pollution exclusions that purport to exclude the presence of virus with contamination language, et cetera. So most of those are yet to be interpreted. I just, as a policyholder, I think it's dangerous to use the term virus exclusion because it suggests a breadth and a scope that just may not be supported by the policy language. Mike, do you want to address that, or do you want to move on to the civil authority, or you want to cover that?
Well, I agree with you, Seth. I think for the courts that have denied motions to dismiss based on allegations, of the presence of coronavirus or whatever was the virus was there, are those cases when they move to the summary judgment stage, right? Are those going to survive and the courts are going to allow those to go to juries? That will be a really interesting question. I agree, because I do think it's one thing to allege that, but then how do you prove it? If you didn't have someone that was actually on site that was sick or had the virus, and then you're relying on various other experts like you're talking about, Seth, that'll be really interesting to see what kind of proof is sufficient to move on to the next stage. But when you're talking about the virus exclusion, and we can talk about, I know you want to talk about civil authority, but just real quick, when you're talking about the broad ISO virus exclusion, here it is. It's essentially saying that the insurance company will not pay for loss or damage caused by or resulting from any virus, bacterium, or other microorganism that induces or is capable of inducing physical distress, illness, or disease. That's pretty broad. So no matter what, my view from the insurance company side, no matter what kind of theory you have, in some fashion, what are we talking about? We're not going to work. We're not serving ribs. We're not serving pizza at restaurants. We're not having patients come in to be examined because of this virus in one fashion or another. That's sort of the policyholder plaintiff theory. If that's the theory, then my goodness, how do you get around this exclusion? And I know some people tried to argue, that there's other causes that try to get around this. I don't know if that works very much, but you're right. You have to be very careful on the policyholder side when you talk about virus exclusion. When I talk about virus exclusion, this is what I mean. What's on this screen right here, this is basically the ISO language that's on a lot of policies. And I think it's fair to say that the courts that have denied motions to dismiss and said that there could be coverage for these claims, I don't know if any of them have this exclusion on the policy. And so some of the carriers that have been the target defendants in these cases, the policyholder bar has been very wise to not go after the companies and the policies, I think, that have this exclusion on it. But in any event, that's my take on the exclusion. I mean, do you disagree with that, Seth?
I don't. And in fact, as you can probably imagine, in the weeks after these shutdown orders were first issued in March, our firm and other firms that don't represent insurers were sort of inundated with the following request. Look at this policy. What coverage do I have for business interruption? And it didn't take long for me to stop recommending not to pursue those claims, the ones with the ISO virus exclusion, at least anytime soon. My advice was submit a claim. Let's see what happens. But you do not want to be the pioneer trying to get around that language, because you got an uphill battle. So I do agree with you, but there are other exclusions out there, contamination exclusions that use the word virus. And my view is, I don't think the insurance company is going to win on this, but that's sort of a different issue. Let's just talk really briefly about civil authority, because I'm actually more bullish about policyholders' chances on civil authority coverage than sort of the general insuring agreement. And civil authority coverage is often sublimited, which might be why we're not seeing more of it. But just very briefly, when we're talking about civil authority coverage, most property policies contain a provision that states that if there has been physical loss or damage to property that is near the insured property, but is not the insured property. And I use the term near, it's actually never near in the policy. It's usually a set space, is it 1 mile, 100 feet, 500 miles, or this was 100 miles, which is very unusual, but be that as it may, if there is that sort of damage and a government order prohibits access to the insured premises, then that coverage will be triggered and the business interruption loss is triggered. So it doesn't change the analysis of anything Mike and I have been talking about today. You still have to show physical loss or damage, but envision this argument. How do you get around this idea that there was the presence of the virus on the property, there wasn't the premises, et cetera? How do you prove causation? Well, it seems to me the much easier argument is you argue that the virus was in, and this is a better argument in urban settings where the businesses are sort of adjacent to each other, but the argument that there was physical loss or damage. The virus was widespread. It was across, it was prohibiting access. It was causing damage to all these facilities. As a result, governmental bodies issued shutdown orders, and the causation is the shutdown order. Now, I don't know if there was a policyholder interference or not, but some of the shutdown orders, the ones out of, I think, New York City, there was one out of California, expressly refer to property damage, which helps quite a bit, saying that they were issued because of property damage. Is that binding on I don't know, but it's just sort of an interesting aside. Mike, have you seen anything on that front?
My take on it is I agree, with the civil authority coverage, you're having to show that there's, you still have to show the direct physical loss, but it's got to be to other properties somewhere else, like in the example of the language here, within 100 miles, that may be easier in some ways, to show. Maybe I can't show it was in my shop, but I can show it was certainly in the restaurant down the street. What I get hung up on and why there would be coverage for this is typically we have this requirement, like you see in that first case there, that the order that shut you down had to specifically prohibit access to the described premises, that is your place. So even if I can show that the barber shop down the street, that people were sick there and there was an order shutting us all down and that's why we couldn't have business, I don't know if those orders really say, but you can't go into your place. It says maybe you can't do business, maybe you can't sell donuts, but it doesn't say you can't go in there. Now, I'm not saying that there are no orders that say that, but the orders that I have seen have not done that. And I know the counter to that is, well, our access is effectively denied because we can't use the property for what we use it for, but that's, literally it says access to it has to be prohibited. And that's the requirement that I get hung up on.
Yeah, and I will note, and I see that we're finished, but I will note that in the North Carolina case, I think the judge noted, well, it doesn't say complete access. It doesn't say full access. It doesn't say full suspension. It doesn't say complete suspension. That's the gray area where these cases are going to be decided. So with that, I see that we're done. As you can tell, both Mike and I are very passionate about these issues, enjoy talking about them as Mike and I tend to do, the respective sides. So if anyone wants to discuss further, has any questions or insights, please reach out to either of us, because Mike, I hope I can speak for you when I say I get a kick out of talking about this stuff.
Absolutely. Like I said, there's a reason why they call me Mr. Excitement at the office there, and this is it.
Thanks,
Oh,
everyone.
Mike, Seth, thank you so much. We always look for cutting edge issues, and this is about as cutting edge as we can find. I know that the 71 folks who are currently on our webinar will stay tuned as these cases unfold, whether it's summary judgment orders or trials and judgments and appeals. So my guess is we probably have several years ahead of us before we have some real answers. But if nothing else, I am confident that we will be seeing flashes of what's going on in Mike Young's LinkedIn posts every day.
Absolutely. Absolutely. But please join.
Very good. Seth, if it would be all right, since you have a lot of terrific cases and language in your PowerPoint, could you forward a copy of that to me or to Kelly of my office, and we'll distribute that to all the attendees?
Of course.
Very good. Very good. Well, on behalf of all of us at USA&M, I want to thank Mike, thank Seth, all of our presenters today. I want to also thank Kelly Spiller of our office, who is the one who presents and puts all of this together, and was the one who stuck her head in this conference room about 55 minutes ago to say, don't forget to push the recording button. Also, I put in the chat the Missouri CLE program number when you're going to go in and update your CLE records with MOBAR CLE. A copy of that certificate number is on your CLE certificate that was part of the materials that Kelly distributed to you. Last but not least, put down on your calendar January 28, where we'll have our next best practice program. I wish everyone safe health, be well, and we'll see you at the next time around. Thank you so much. Good afternoon.